Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
Okay,
Absolutely. Thank you. Give me 1 second. Give me 1 second.
I'm gonna pass that. All right, the court will call the matter of Ms. Natasha Austin, case number 24S00019. Virtually different for the people.
Assistant Public Defender Allison Miller here on behalf of Natasha Austin. Ms. Austin, can you please state your name?
Natasha Austin.
Thank you, Ms. Austin. All right, we're here today for a review in this case. How are you doing now, Ms. Austin?
I'm good. I'm fine.
Okay. So the referral's going over for her to get into the anger management course, correct?
Correct. That's my understanding.
And you start a job next week, Ms. Austin?
No, I get my first paycheck next week. I started this week.
Oh, did you? Okay. How's it going for you?
It's all right. Getting back on my feet.
All right. Well, the recommendation at this point is for another review with Agent Johnson in 45 days to see if you are in the anger management course, because that's what we're really concerned about. That's how you ended up in jail. So we got to make sure we can get that under control, right?
Mm-hmm.
And so anything else you want to say on behalf of your client?
No, Your Honor. Thank you.
Ms. McDuffie, anything from you?
Nothing for the people.
Anything else from you today, Ms. Austin?
No, ma'am.
Thank you. We'll see you back here with Ms. Johnson in 45 days. So that'll put us on October 24th,
Okay.
2024. And she may give you a different timing of that, but that's what it looks like to me at now. And I'm gonna set it for 9 a.m. unless Ms. Johnson wants to jump in with a different time or date at this time.
Okay.
That's fine. And then just call community corrections later on today to get that class started.
Call up there.
Yep.
Okay.
And you'll get the referral in your email today. So I'll have that information.
Can you send the number too?
I sure can.
All right. Thank you.
You're welcome.
Thank you. Have a good day, Ms. Austin. Take care of yourself.
You too. Bye.
State of Michigan versus Joshua Gordonier, case number 22S00943.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Joshua Gordonier.
Joshua Gordonier.
Thank you. Mr. Gordonier, good morning.
Good morning, Your Honor. How are you?
I'm okay. So, Mr. Gordonier, you're here today for what would have been your first review, but there is a violation of probation that has been filed against you. I'm going to arraign you on that violation at this time. The violation indicates that you failed to provide adequate proof of your 12-step meetings as ordered, and that you violated the terms of your sober link via community corrections report. That report indicates that on we had a number of failing to test. You missed the scheduled test on June 17th, 2024, between the times of 9 p.m. and 12 a.m. And June 23rd, you tested late. June 27th, you missed the test. July 7th, you tested late July 24th. You did not test between the hours of 9 p.m. and 12 a.m. August 1st, you didn't test between the hours of 9 p.m. and 12 a.m. You stopped testing at one point on August 7th for a total of 13 tests.
I went to jail.
Oh, you went to
Gonna
jail?
explain in a minute, Mr. Gordon.
And then August 14th, 15th, and 16th, you missed the testing between 9 p.m. and 12 a.m. And then you tested early on those dates. Well, there's just a lot of those. I think the main concern is the time period that he completely missed. All right, you had a chance to talk to your client about this. I see. What would your client like to do? He has a right to have a hearing on this matter, at which time, if he is found guilty, he could be subject to violation of his probation. And let's see, these are, oh, and it also says there's another violation that you failed to report for over 90 days. And that one is a non-technical violation for which you could get up to the maximum penalty on this particular matter. Ms. White, what would your client like to do?
Admit with explanations.
All right, thank you. All right, Mr. Gordon, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You may lower your hand. Is it true that you missed during those time periods that I just mentioned to you, sir?
Yes, ma'am. So when I was originally testing, I thought everything was going good. And I'm also in court in Novi for a DUI. When I went into court, the whole reason I changed all my times is they said that I missed 10 times. And I told the judge, I test when I'm supposed to. And he said, don't you think 9 to 12 is a little late to be testing? And he gave me 10 days in jail. So I went to jail. And as soon as I got out, because that was my sentencing day, they gave me 10 days and 2 years probation. So I got out at 2 a.m. I came home and I tested at 6 in the morning. And that's when I started testing at 6 to 9 p.m. I'm sorry about the whole confusion. I'm not meaning not to report. Look, I'm going to AA. I've been doing my classes.
Did you not report though? Did you not report to probation?
I go to the website and I fill out the information and I click it in.
Do you? Okay.
I mean, if it's a technical problem, look, I got a job. I'm here on my lunch break because I can't get my phone to work, Zoom. I'm sorry. I know that I have forgot to send these in a few times, but I have been doing that thing online to report. I'm doing my classes. I'm trying to do everything on both sides that everybody wants me to do.
It sounds like he is willing to admit to the violation with respect to the failing to blow or in the sober link face timely, but he is not acknowledging that he failed to report. He's indicating that he did get those, so that's not a technical admission to the violation.
Can I be switched back to the tether, please? If this is a big problem.
Sir, you need to wait a second until we finish this process.
Sorry.
Ms. White?
Yes, we did talk about his online reporting. I believe the only reason he's admitting to it because he said
he's not admitting to it.
Well, he went online and attempted to do it, but he said he must be doing something wrong because every month he thought he was doing it. And maybe he's not actually submitting it the way he thought he was. So, yeah, I guess so. We don't know which way to go with that.
Ms. McDuffie, what are your thoughts on that part of the violation?
So I heard Mr. Gordon say he goes online, he enters this information and he clicks it in, but then I also heard him say he admits he's forgotten to do some, and it's not.
He forgot to send in his 12-step meetings, I think is what he's talking about, not the, that's the impression I got. He's only talking about failing to send in his 12-step meetings, not failing to send in his online reports. Am I correct, Mr. Gordon?
Yeah, because it was my impression I'm supposed to send those to the website, to her email address.
All right, thank you, sir.
Okay. It wasn't clear to me before whether he thought he may have been confusing reporting between this and his other court, but it sounds like he believes that he has submitted all of his online reports. So
I know that I missed 1 or 2 of them that I forgot to blow. I know. I'm just talking
Not
about
the
in
blowing.
general.
I'm not talking about the blowing, sir. We're talking
Oh,
about submitting your online reports.
The monthly reports
Sorry.
for probation. Yes. So that's what's confusing us, is because he keeps saying that. So so if he does believe that he has entered all of his online monthly reports to probation for this case, then no, we don't have an admission there. I just wanted to clarify that. So I'm happy accepting the ones for the SoberLink issues.
Mr. Gordonier, is it your position, sir, that you submitted every report that you're supposed to submit in terms of online reporting online to your probation agent? Is that your position? Is that what you're saying?
I thought that I have been.
So is that a yes?
Yes.
Okay.
But
So we,
can I say one thing though, real quick? If the last time we had a problem and and we went to trial or whatever, you put me in jail for 20 days. I don't want to do that. I don't want to cause any extra problems. So whatever, we have to do, we could settle today. That way, I'm sorry. I just want to work and provide for, my wife and kid. I'm not trying to do anything wrong.
I'm willing to accept his admission for the SoberLink. And the recommendation is not that he have the entire time of his entire time period in jail at this time anyway. It sounds like he was in custody. If we can get proof of his in custody time for the 13 missed tests, that obviously changes the court's view on where Mr. Gordonier is. He can't test if he's in custody. So we're going to need proof of that, Ms. White.
Okay.
I have it. Would you like me to get it? Oh, I can't see it anyway.
No, I can't see it. You need to give that to your attorney. So what I'm going to do today is accept the admission of responsibility for the SoberLink.
Your Honor, I can actually speak to that. I'm looking at his ROA from his case in Novi. I do see that he was committed to the Oakland County Jail on August 7th of 2024 for 10 days.
Okay. All right. Thank you. All right. So I'm willing to give Mr. Gordonier another chance, and it sounds like he wants to go on the scram tether as opposed to the SoberLink.
Yes, please. If it's this big of a problem, yes, please.
Defendants ordered onto the scram tether. Hold on one second. How long do you think we don't have the ability? We can send that information. Shannon, are you sorry, Ms. Straub, are you gonna be able to?
That's okay.
You're gonna be able to send the information over for him to get on SoberLink, Scram at today, given our internet situation?
Yes. Yep, I can do that.
Okay. All right. So, sir, you need to report within 24 hours to get the scram tether placed on, okay?
I'll go right now. My wife take me.
All right. And then go ahead, Ms.
I just wanted to suggest, I know that Mr. Gordonier does not want to go to jail again after his last hearing. I would just suggest that he stay in close contact with probation. Don't necessarily, assume that it's going to all get resolved at your next hearing. If you know you've been incarcerated and you've missed tests or things like that, I would suggest reaching out to probation immediately to let them know that, so that you don't end up with the violation and they know what's going on. That was all.
Sorry, I thought you guys all talked to each other. Knew it.
Not at all, sir. Every court is independent and do their own thing.
Sorry.
Okay. And so can you also, I'm going to ask you to go online and submit a report within 24 hours. So that way we'll know if there's a problem with your reporting, and you can try to work that through with your attorney and Ms. Straub now, so we don't have issues in the future. You shouldn't assume that the report is in. You should contact them and make sure they got the report. Via email is probably best, right, Ms. Straub?
That's correct, Your Honor. I don't think my phone works from here either.
Right. Okay.
Oh.
So, all right. You want to, any more questions, sir?
No, no. So I get to go put the tether back on and I don't have to worry about blowing and we're good
Yes.
today?
that's correct. Yes.
Thank you, Your Honor. I'm sorry.
All right, so tether on, submit online report within 24 hours. All right. And I will see you back here in 60 days on October 31st,
Thank you.
2024 at 10 o'clock a.m. Okay.
Yes, ma'am.
All right. Thank you, sir.
Thank you.
You're welcome. All right, the court will recall the matter of the state of Michigan versus Brittany East, case number 24 FB 1070.
Rachel McDuffie for the people.
Assistant Public Defender Davi Luba on behalf of Ms. East. Ms. East, could you state your name, ma'am?
Brittany East, can you hear me now?
Yes, I can. Thank you very much. Can you hear us? Is the question. I think we could hear you at one point, but you couldn't hear us.
Yes, I can hear you.
All right, great.
Nice to see you again. Sorry, I came in yesterday.
Thank you. You did. I remember that. You said you'd see me tomorrow, and today is tomorrow. All right. Ms. McDuffie, if you could repeat what you said so that she can hear what your comments were, please.
Yes, Your Honor. So first and foremost, I agree with the recommendation. The sort of question I had was, I guess, as to how much insight Ms. East really has about what happens in this incident, given that she admitted in the report and in her interview with the employer that she did what she did and took this money because she needed to help her family out and they felt fallen upon hard times. And she was trying to get everybody back on their feet with utilities and everything. But then I see in the PSI that she says that she took the fall for a coworker. And that disconnect is a little bit confusing and troubling to me. So I don't really understand where Ms. East actually is in terms of what happened here and what she is taking responsibility for doing.
Thank you. Anything further from counsel on this? Is this Ms.?
Yes.
Ms.
Yes,
Lee?
Your Honor. Thank you. I do want to respond to that because I do believe I can clear up Ms. McDuffie's concerns in two respects. One, which is I'd like to
courts, I want you to be very clear that that's the same concern that I had after reviewing the report that she filled out herself and her statements to the probation department.
Absolutely, Your Honor. Firstly, I do want to note this is a case where Ms. East did plead no contest rather than guilty. With regard to the specific concerns as the incongruity of her statements, my understanding that Ms. East's position is that she was paid by a coworker in order to admit to the offense. Is that correct, Ms. East?
Yes.
Ms. East, is there anything you would like to say prior to sentencing, ma'am?
I'm sorry I did something stupid and it was my fault for going along with it. I should have stopped and taken a look, and I'm very apologetic, and I'll take full responsibility for it because I know it was a stupid mistake.
Thank you. So as I read through these missing change order statements from someone named Joseph Halperin, explaining this one was a change order and the others were actual money missing from the till from the petty cash. As I read through those and look at what they're indicating, it appears that her version of what happened at this point is very different than the version of what the evidence would show. When you plead no contest, you accept as true everything that is being said in those police reports. The police reports and the statements are indicating that the petty cash and the registers were short on 2 days, and there was a change order that happened and the money was missing. And Miss Brittany East was the person who was actually involved with both the counting of those registers and as well as the money when it was missing from Brinks trying to pick it up. So I'm not buying her concept of what happened in this case. And I'm very concerned, just as the prosecutor is, about her own accountability. She needs to be accountable for what happened here, not just giving us a statement that someone paid her to do it. I don't buy that. I don't buy that someone paid her to take responsibility for what happened here. The evidence shows that she was the person who did this, period. So I'm not happy with that. She may have pled no contest, true enough, but to say that someone paid her for something that she's accepted responsibility for is concerning. Having said that, I do believe that the recommendation is still what should happen in this case. I just hope that she takes it very seriously and follows the court's orders in this case. Because if she doesn't, the court will recall that she failed to accept responsibility for it. And that's when the issue becomes a real issue for her. Are you understanding this, Ms. East?
Yes, I do.
All right. You're on probation. It is the sentence of this court that you serve 365 days in the Washington County Jail, credit for 0 days, and all of that is suspended. So you don't have to do any jail time unless you don't follow the court's orders. You're on probation for 18 months. Fines and court costs in this case for a total of $325. Restitution to AutoZone in the amount of $1,540. You are to complete the ABR theft intervention program within 60 days. Do not go to AutoZone, and I'm going to bring you back here in 60 days on October 31st in order to see if you're making payments and completing that programming. Ma'am, I do accept that you have some health issues going on, and I hope that those are getting better. I do accept that part of what you said, but the rest of it, I'm not buying it. So I hope that you complete this program and we don't have any issues. Okay?
Yes, ma'am.
I'll see you back here on October 31st at 10 o'clock a.m.
Thank you, Judge.
You're welcome.
Thank you.
You have the phone number for the probation department, Ms. East?
My phone number?
No, do you have the phone number for the probation department?
Oh, no, I do not.
All right, let me give you that so you can call them tomorrow after 9 a.m., okay? No,
All right.
you can call them on Tuesday, September 3rd after 9 a.m., okay?
Okay, I'm getting a pen right now. Go ahead.
All right. All right. You've got it, the pen?
Yep.
Okay, 734-483-7336.
Okay, thank you.
All right, thank you. Call them and they're gonna schedule a time to go over what your requirements are with you and sign your probation contract. And your probation is non-reporting, okay?
Thank you so much, Judge.
You're welcome. Take care of yourself, ma'am.
I will have a good day.
Thank you, you too.
Hopefully I don't see you.
Hopefully, well, you're gonna see me because you gotta come back for that
Well,
one.
hopefully I never see you again for a new case.
Okay, yes, that we can both agree on. All right, thank you. Take
Okay.
care, Missy.
Have a good day. Bye-bye.
You too.
Thank you.
Bye-bye. One moment, everyone. All right, there is a phone number that we allowed in here, Motorola Moto G Play. Hello, sir. Can you please, you're Mr. Mentor?
Yes, how you doing, Your Honor?
Good. All right, the court will call the matters of Mr. Levert Mentor, 17S00401. Good afternoon. Please state your name for me again.
John Mitchell.
Oh, no, I thought you said mentor. All right, one
John
second.
Mitchell, MIT.
Yeah, we got you now. All right. Court will pass the other case that we called, and I'm going to call the case of the state of Michigan versus John Mitchell, case number 18 FB 1742.
Rachel McDuffie for the people.
Kirma Dadush on behalf of Mr. Mitchell seeking permission to practice under MCL 8.120 under the supervision of Allison Muller.
Permission is granted.
Thank you, Your Honor.
All right, Mr. Mitchell is here today for payment. He has set up a $25 payment plan as of August 20th. I didn't see that any payments have been made.
Yeah, it's been bad for me, ma'am. I just today I just got a job interview and I gotta go to Concentra. So I guess that means that I start.
Oh, Concentra, okay.
Yeah. So I guess that means they're gonna call me after I pass the physical. So I will be able to start getting on my job, and take care of that. So today I gotta go and do a physical for a job. And I should be able to start making my payments.
All right, I'm gonna give you a little minute to try to get on your feet. We'll bring you back here on October 31st, 2024.
Thank you, Your Honor.
At 10 o'clock. See if you are making any payments by then, sir. I'm writing down that you told me you got a job, so.
All right.
All right.
Thank you, man.
See you then.
Thank you, Your Honor.
Thank you. All right, we had 6 people in the waiting room. Those are, okay. All of those people? Yeah, they're all, okay. All right, do we want to?
Yeah.
Do we want to call some of our, we're gonna call some of our 10 a.m.s until we hit the 11 a.m. time, and we'll start our final settlement conferences. We'll see how many we can get through. I want to start this timely so we can hopefully finish timely. Our 11 a.m.s. Okay. All right, the court will call the case of the state of Michigan versus Paris Bryant, case number 21S00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Paris Bryant. I did speak with Ms. Bryant. She's going to try to go in and make a payment this morning. She's currently in class and wasn't sure if she could get on. So she's going to try to make a payment to catch up. But looking at JIS, I do not see a payment being made. So I would ask either that this review be adjourned or set for a show cause.
Defendant has failed to appear, failed to pay. She was here. Was she here last time? Looks like she was. It says defendant made 1 payment. Okay. All right, show cause will be scheduled in this case for October 31st, 2024 at 10 a.m. The defendant fails to appear. Okay, this warrant will issue. State of Michigan versus James Liggins, case number 23 FB 1057.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of James Liggins. Your Honor, I reached out at least 2 times to Mr. Liggins. I can't remember if his number was working. I think I left a voicemail, but I did try to contact him. I haven't had any contact. Was unable to go over his review with him.
All right, one moment. So it looks like he has not provided any proof of his mental health assessment. And he's reporting he made some payments. Ms. Johnson, in light of the fact that he's not here today, do you have a recommendation as to what you would like to see happen?
I did give him the option at the last hearing to consider switching, and he was going to try to work out the HEAL program, but I had not heard anything in regards from the facilitator. Given that he's not here and I don't have any updates, we can issue a bench warrant because we've given him ample time to get things going.
All right. Thank you.
Thank you, Your Honor.
Bench warrant to issue. I'm gonna set it at 5,000, 10%. State of Michigan versus Levert Mentor, case number 17-00141.
Rachel Deputy for the people.
Kerma Dadush on behalf of Mr. Minter seeking permission to practice under MCL 8.120 under the supervision of Ms. Allison Muller.
Thank you. Permission is granted.
Thank you, Your Honor. Your Honor, Mr. Minter dropped off a payment yesterday. He said that when he dropped it off, it was a money order. He said that when he dropped it off, whoever was at the front desk told him that the computers were down, so the payment may not show up or may not process. I told him to show up today, and I called him like 20 minutes ago to tell him to show up, and he said that he was going to log in, but he had to drop off his daughter or something.
Okay. But what I'm gonna do is, he had been current every other time, and I see he made a payment in July. So August would have just made him current. Now I'm gonna accept him as current.
Thank you, Your Honor.
And I'm gonna put that over to December 5th, 2024 at 10. He has been paying consistently since, I think, February. So I'll give him the benefit of the doubt this time because we can't confirm it.
Thank you, Your Honor. I do appreciate that.
Thank you. State of Michigan versus Warner Threats, case number 21-00413.
Rachel Deputy for the people.
Assistant Public Defender Sandra White on behalf of Warner Threats. I did attempt to reach out to Mr. Threats with no success. I see no payments have been made. I would ask for an adjournment of the review or a show cause hearing.
Mr. Warner Threats is the opposite of Mr. Mentor. He hasn't made a payment since this plan started. So he's not here today, but he was here at the last hearing when he asked me to reduce his payments to $50 per month, which I did do. So defendant failed to appear, failed to pay. I'm gonna set it for a show cause. I'm not gonna give him much time though. I'm gonna set it for October 10th, 2024 at 10 a.m.
Thank you.
Oh, these are not.